Okay, I'll call this meeting to order. Welcome everyone to Senate Judiciary. It's good to have everyone back. And just as a reminder, we're Zooming live as usual. So careful with your sidebar conversations, and we're going out to the world. We've got quite a little bit of work to do, and a couple folks will dip out, including me, to go present bills elsewhere. So I will say that up front. We're going to take up Senate File 45 first, Vulnerable Adult Civil Cause of Action 2, sponsored by Senator Nethercott. Senator Nethercott, good morning. Welcome back to Judiciary. And take it away. Tell us about Senate File 45.
Thank you, Mr. Chairman. Did you want to do roll call? You don't do roll call. Okay. So, Mr. Chairman, good to see you this morning. Thank you for seeing me on this President's Day. We are hard at work here in the Wyoming legislature. Good senators, what you have before you is the work of the Mental Health and Vulnerable Adult Task Force that met over the interim and produced a variety of bills. This bill, unfortunately, due to the timing and logistics of the different committee meetings, was unable to be heard by you in the interim and hopefully adopted by you as a joint judiciary bill. So because of that timing delay, I offered to take it up as an independent bill and present it to you, hopefully for your support here today. As you know, the task force over the interim evaluated some deficiencies in our laws concerning how we can better protect vulnerable adults in our state. And a vulnerable adult really can be both someone who is elderly, as what I think is most commonly referred to, but it also can be someone who is disabled and doesn't necessarily mean of advanced age and infirm in some way. And so important to recognize, I think, the breadth of whom a vulnerable adult may be, and then also what exploitation is. Now, it is a crime to exploit a vulnerable adult, typically, but that requires law enforcement intervention. And what that looks like can be pretty complicated, I think, for much of our law enforcement. Sometimes it's involving a power of attorney or other type of position of trust that the vulnerable adult may have. And law enforcement quickly just defaults to, this seems to be a civil issue and something that we will not prosecute. I think they're also just challenged with manpower in order to really investigate and understand some of the challenges that can take place with the exploitation of a vulnerable adult. And so recognizing that, I think, tremendous gap in our law in order to provide those protections, the committee felt that providing a civil cause of action, allowing for both punitive damages, your typical compensatory damages, which is in order to make the person whole, and then attorney fees, was an appropriate remedy, allowing for a variety of people in the vulnerable adult's person's life to act on behalf of the vulnerable adult to pursue those remedies. And so if you look at the bill, you can see here, really it starts on page 1 on line 12. A vulnerable adult shall have a cause of action against any person who has exploited the vulnerable adult. So that's the first requirement, to know that the exploitation has to be proved and has to have occurred. And then the vulnerable adult may recover actual damages, that's that compensatory damages, in order to make the adult whole, or the estate whole, and I think that that's important to recognize as well. Punitive damages, and that means that the court or the jury would be able to assess damages in order to punish the individual or people responsible for that exploitation, and then of course attorney fees. The action may be brought in a court of competent jurisdiction, so in any state, in Wyoming, the district courts, that's typically what that refers to when you see that language. And here's where the breadth of the bill really lies about who may bring the vulnerable adult. At first blush, this causes great hesitation because it seems so expansive. And I heard some comments from lawyers, and when I first saw it, I too shared that concern about who can bring the cause of action on behalf of the vulnerable adult. And I think that response is fair and a fair criticism until you think it through. If a vulnerable adult has been exploited, shouldn't a remedy be sought on behalf of that vulnerable adult? And limiting who may be able to do that isn't really in the public's interest or the vulnerable adult's interest. I think typically when we think about expanding who may sue on behalf of someone else, we consider that standing. And we don't want to open that too broadly unless the person has a direct interest in it. And of course, in this case, that direct interest is the vulnerable adult who likely can't act on their behalf. The bill does allow them to do so, but more likely than not, they're unable to act on their behalf. And so in order to hold accountability to the bad actors who would be exploiting that adult, we really want to open it up to all of those who have a direct interest in that vulnerable adult and can therefore act on their behalf. I don't think this will result in a race to the courthouse in order to sue people for exploitation of a vulnerable adult. I think it actually serves as a very important tool that is currently lacking in our law. And so with that, I'm happy to stand for questions. I can walk through that list for you, but you can certainly read it as well. So happy to stand for questions that you may have.
Okay, thank you very much, Senator. Questions for Senator Nethercott this morning on this bill? Senator Schuler.
Thank you, Mr. Chairman. When I looked over this bill, I only had a couple of questions, and one of them would be, once we determine that they've been exploited, and there's all these, the laundry list here of all the folks that might be able to help them in a situation like that, and let's just say they get a damages, possibly, I don't know, who knows how much, but let's just say they're 19, maybe they're living alone, they don't have a guardian for 20, 21, where does that money go? Would it go back to them? Would they be able to take care of that, depending on their situation? That was the only question I really had. Thank you.
Senator Nethercott, go ahead.
Thank you, Mr. Chairman. Great question. It would depend on the circumstances of the vulnerable adult. More likely than not, I would anticipate as a result of their exploitation, it would be prudent to establish a conservatorship, and a court would require that, and or the placement of those funds in a restricted account that the court would also require. Either of those requires court approval of the expenditure of those funds and annual reporting to be conducted regarding how those funds are held and utilized.
Further questions? Any other questions? Go ahead, Senator Case.
So, Mr. Chairman, I assume that this bill would make it easier for these people to go to court, as opposed to currently, if any of this laundry list of people went to court, the court might rule that they don't have standing. Is that kind of the issue, or they're not connected enough to it to be able to bring it forward?
Senator, go ahead.
Mr. Chairman, yes, that is correct. And so oftentimes, as we all know, individuals fail to do proper estate planning. I strongly encourage you to do so. As a result of that, some of these individuals who would typically be identified as being able to act on their behalf, such as a power of attorney or a guardian or a conservator, be limited to those individuals who may be able to bring it. Interestingly, the bill also on page 2, line 9, allows the personal representative of the estate of a deceased vulnerable adult. And so this is also, I think, important for the heirs of that vulnerable adult. Oftentimes that exploitation can occur immediately before death, perhaps when many of the children cannot be around as frequently as they would prefer or the family would prefer, and that vulnerable adult gets exploited right before they pass. There's really no remedy in the law to recover those funds. Law enforcement, again, isn't particularly interested. The vulnerable adult may have agreed in some capacity to some of the usage of their monies or other types of exploitation. And this allows also a remedy for that bad act to receive some justice.
Thank you.
So, Senator Nethercott, sometimes very difficult to prove and a tough case to bring, isn't it?
Mr. Chairman, it certainly is. And so that is also where I think there's just a pragmatic caution about who and how often these cases will be brought. Someone still has to pay for an attorney to take the case, to then pursue it and litigate it successfully. And that requires a careful analysis and application of discretion about the successful prosecution in one of these cases in a civil method.
Thank you, Senator. Appreciate it. Anything else for Senator Nethercott this morning? Is there anyone else who would like to come forward and testify on this bill? Anyone else who would like to testify on Senate File 45? Please come forward, and Senator Nethercott, please stay at the table in case we have questions or additions or subtractions. Good morning. That's right. Good morning. Hi, golly, we know who that guy is, but you know the deal. So
happy to introduce myself. Good morning, Chairman Landon and committee. I'm Tom Laycock, representing AARP Wyoming. We're a membership organization for those 50 and over, and we support the bill. Ask for a small amendment, but very supportive of the work the task force did, as well as the sponsor here today. Through the interim, we put a lot of miles on the truck following around this task force, and the role that we look at ourselves as having in this particular effort is to, sort of act as the consumer protector for the older adult, specifically. So make sure that we've found kind of a nice happy medium between what's trying to be done and make sure that no one's really losing rights or having any concerns with that. But we do like this in a big way. We appreciate those who might be impacted by measures like SF 45. We also shared it with our own in-house attorneys, our consultants who deal specifically in conservatorships and guardianships. Once again, the shared analysis is we think this is a great idea. Offers another tool for those who may have been taken advantage of. We're fully supportive of the civil cause of action. Our request does come in the amendments following in terms of who's allowed to bring the civil cause of action. Specifically, page 3 of the bill, we'd request deleting lines 11 through 15. Those lines would allow for a person who has been asked to accept the vulnerable adult's power of attorney or the nursing facility where the vulnerable adult resides to be able to bring those actions into court on behalf of the vulnerable adult. It's our concern that someone who may have been asked to accept a vulnerable adult's power of attorney could be someone who's only recently been asked to be the POA at the time when there's a question about the person's capacity or susceptibility being unduly influenced. So for those reasons, we'd ask for the amendment, but lend our support to the bill.
Okay, questions? Questions for Mr. Laycock? Go ahead, Senator Schuler.
Thank you, Mr. Chairman. I actually did have a question about X, the nursing home. I really thought that might be kind of iffy, and I don't know why. There was a question in my mind I could see that going, I could see bad actors getting involved there. So I did have a question on that. I don't know if it needs to stay or needs to go, though.
Mr. Laycock, what maybe you could expound on the concerns there a little bit for us.
Sure. Mr. Chairman, Senator Schuler, we were trying to come up with a situation by which that would be sort of appropriate. And that said, I did talk to our friends at Leading Age, and they said, we did have an instance where it would have been really nice. We couldn't get police or investigators to really do anything, and it would be nice to be able to bring that. Now, I don't know that I necessarily feel the same way. I feel like it could be seen as a little bit self-serving if there are outstanding fees by the resident. So I think that's my concern.
Mr. Chairman.
Okay, Senator Case, go ahead.
Just trying to drill down on this proposal of Mr. Laycott's, and the language 39102A Romanet I refers to this. It's under the definition section, and it says under A Romanet I, it says agent means a person granted authority to act for a principal under power of attorney, whether denominated an agent, attorney in fact or otherwise, period. Agent includes an original agent, co-agent, successor agent, and a person to which an agent's authority is delegated. And so I'm thinking about that definition. That's a broad definition. And I think if I understood Mr. Laycott's testimony, sir, or your testimony, you're trying to get at the situation where people are kind of drug into something when they've just been appointed, and maybe that's what happens when you enter a nursing home or something like that, I assume. Is that where we're getting at? That amendment, that's pretty broad. So help me with this. Did I make any sense? It's okay if I didn't. Happens all the time.
Mr. Laycock, help us out here.
Chairman Landon, Senator Case, I think the concern being that just someone who's been asked to accept vulnerable adults, power of attorney, the question is there is a process, obviously, for becoming a power of attorney. And the concern is that someone pops up and says, well, she just asked me if I would do it. So I feel like I may have standing there. Obviously, the state attorney to my right is much more knowledgeable in those particular instances than me, but it feels a little bit broad. And once again, we're talking about the concern being those people who may have sort of attached themselves to the vulnerable adult a little bit later in life.
So go ahead, Senator Case.
Mr. Chairman, I guess that's the point we all need to talk about is you're proposing to remove the reference to that definition that I read entirely, so they would not have standing. I see how there are people within that definition, such as you described, recently appointed casual agents, but it seems like it catches all sorts of different things that may have something they can bring to bear on the court proceeding to protect the vulnerable adult or their estate. So I'm trying to, maybe we could cut that down a little bit. I don't know. I'm not sure.
So, Mr. Laycock, I want to go to
Mr. Chairman, yes, we certainly did. And I think probably what's happening, if I may be so bold, and you know I may, the lawyers saw that and said, whoa, that's way too broad, and strike that. We don't like it. In a nursing care facility, whoa, we don't get it, strike that. Why? Because we know the legislature doesn't do good work and they need help, and here we are bringing our expertise, and strike those things that don't make sense to us. But I think that's just a very superficial review, and it lacks maybe the second and third level analysis. One is a person who's been asked to accept a vulnerable adult then can sue someone who's exploited that vulnerable adult. Does it matter the frequency and time of which they've been asked to be an agent for that vulnerable adult? I hardly think so. I think what the concern is that a vulnerable adult may ask somebody while they're in a vulnerable state to be a power of attorney, and that person may not be a wise choice. Regardless of that analysis, then that person is likely the individual who's been exploiting the vulnerable adult or could be. And so I don't think it's a pragmatic or practical concern if that tracks. And that individual then has to sue someone else on behalf of the vulnerable adult in order to pursue that remedy. So I'm not sure that concern is practical on the ground. I think to Senator Case's point, I think it is technically much broader in application to who is a power of attorney and who can be a power of attorney on behalf of a vulnerable adult or any individual. And so I do think that is there. The nursing care facility is a curious piece. And again, you have to convince a nursing care facility to sue an individual for exploitation of that vulnerable adult. This is not a mandate. This is very discretionary. I find it very unlikely that they would be interested in doing that. But in those rare circumstances where they have seen that exploitation occur and are without a remedy for that vulnerable adult, I think sometimes they can be in a better position than many others to take action on that vulnerable adult's behalf. As a reminder, and there's concern about the nursing facilities' debts that may be owed to them by the vulnerable adult. Certainly, no doubt that is part of the analysis that a nursing facility would take. But the remedy goes back to the vulnerable adult. So if successful litigation ensued where they was able to receive monetary compensation on behalf of the vulnerable adult, that money goes back to the vulnerable adult, not the nursing facility. So they still would have to go through the typical means of recovery, either from the vulnerable adult, the vulnerable adult's estate, other types of recovery methods concerning what would be owed to them on behalf of the vulnerable adult. However, that can allow, and this is pretty complex area of law for nursing care facilities and other type of healthcare facilities similarly situated, for how that individual may be eligible for able to receive access to healthcare. And I will leave it there, but it's not quite as broad and ill-advised as it may first appear.
So, Senator, thank you. I appreciate you fleshing that out. And I knew the task force had probably touched greatly on that. Any other questions for Mr. Laycock this morning? Anything else for AARP? Tom, thank you very much for being here. Appreciate it. Anybody else want to testify on Senate File 40? Please come forward. Yeah. Let's go with agency first. We can bookend the good senator right here. Marcia, please come on forward and be ready. That'll be great. We'd sure like to get through 3 bills this morning, and all 3 of them are important. So, good morning. Welcome.
Thank you, Mr. Chairman, members of the committee. My name is Corin Schmidt. I'm the director of the Wyoming Department of Family Services and served on the task force with Senator Nethercott. And 1, I'm here to answer any questions since this does deal with vulnerable adults, but 2, to kind of add a little bit to the testimony. Having an opportunity or having some of these tools in the toolbox is very important. Right now, we are pretty restricted on how we are able to pursue anything as a result of an adult being abused or neglected under the vulnerable adult statutes. And what we know is that a lot of the financial exploitation is done by family members. And so when you have family members or a family member that is exploiting the adult financially, sometimes other children, siblings, don't have a remedy to be able to address that, many times because the vulnerable adult themselves is real reluctant to get involved. So it kind of goes, I think, to the nursing home example, the skilled nursing facility, that, you know, when you have adults living in these facilities get to know the families very well. And they do see times where there is a child that is exploiting and are pretty limited on anything that they can do to help that family other than refer to us as an agency. And then we're pretty limited as well.
Director, thank you, and I'm sorry I missed you first. Appreciate your service on that task force, and just want to say before I forget to say it that the task force did some great work. We've had a couple of other bills, as the senator alluded to, and this is the 3rd, I believe. Any questions of family services this morning? Go ahead, Senator Schuler.
Thank you, Mr. Chairman. Just out of curiosity, those of you that were on the task force, I was just kind of curious as to know, are we seeing more of these vulnerable adults with the elderly, or is it more of a young, like 20-year-old that's living on their own that, maybe is disabled or whatever? Did they talk about the cases and where we're seeing most of this happen?
Any one of the 3 of you would be terrific to handle that. Do you want to try it, Senator Nethercott?
Mr. Chairman, thank you. I don't think there's good data actually available. And so when I made that inquiry to many of the stakeholders in the room and other members of the task force, the data is not great. And for one of the reasons that the director pointed out, which is the vulnerable adults don't want to report and are pretty hesitant to report. And so there's that concern. And then just the inability to really have a remedy actually available. And so no one is seeking it for us to collect that data. In my anecdotal observation, it would be primarily concerning elderly. That's my practice has been dealing with that for quite some time, and that would be my observation from practice.
It strikes me, Senator, just the very fact that they're vulnerable and maybe don't have a lot of energy, a lot of time, and just cannot be convinced that a friend would do that. we actually had a situation in our family where a lot of jewelry disappeared. And there's not much you can do.
Love that brooch.
No. Yeah, it's such a tough area, and really glad that we're taking this up as a task force now at the session. But anyway, yeah, it can be a really rough deal, and it's really hard for those vulnerable adults to even want to take action, isn't it?
Mr. Chairman, it certainly is. I think more often than not, and even in my experience, that the answer is always no. As the director indicated, it oftentimes is a family member or someone that has historically been trusted in order to get that close to the vulnerable adult. And so for a variety of reasons, justice is not sought.
Yeah. Anything else for Director Smith before we? Okay, thank you, Corin. Really appreciate it. Ms. Shaner, good morning. Please state your name for the record for us.
Good morning, Mr. Chairman, members of the committee. I'm Marcia Shaner with the Wyoming Trial Lawyers Association. And we too, I feel like, are often watching out for our consumers and members of the public. It's our members who are the folks that are often sought out to help in these sorts of cases. If there is and there is a gap in this in the law, and I wanted to just mention that our members have gone through it, agree with the questions that were brought up by Mr. Laycock that Senator Nethercott has included. Also, we just need to provide a remedy. The law steps in to protect those who often can't protect themselves. And so we support the bill and all the hard work that has gone into bringing it here to you today.
Okay, Ms. Shaner, thank you. Any questions for Ms. Shaner this morning? Go ahead, Senator Schuler.
Just full of questions this morning. Thank you, Mr. Chairman. Yeah, just one other thing that popped up in my mind and when I was reading this bill is, let's just say the vulnerable, can't say it today, vulnerable adult has already established a power of attorney, and that particular person is the one that is exploiting them. What is the cause of action then? I mean, how tough is it to, where particularly if this person was disabled and you know, that situation gets real murky, is there any way that you can take care of that or deal with that?
So,
Mr.
you want
Chairman.
to tackle that one, Senator? Go ahead.
Yeah, Mr. Chairman, in my experience, it actually makes it incredibly harder to actually hold that individual accountable, because based on the tools we currently have in the toolbox, law enforcement goes, well, they had the authority to do that. You had to prove otherwise, right? When you give someone a power of attorney, typically, I mean, depending on what that document states, but typically it affords that person full power over that individual's financial situation. And so really, no matter what they do, they have a level of protection now. The Power of Attorney Act, the Uniform Power of Attorney Act, provides warnings about that you may be civilly liable for breaching your fiduciary duty, because it's a unique additional obligation that one has when you choose to serve as a power of attorney. And there's another cause of action for a review of an agent's conduct that is also pretty ambiguous, but it doesn't allow for the type of remedy that this bill affords. And so in my view, if you had an agent who was responsible for exploiting that adult, I would likely bring both causes of action, both the breach of fiduciary duty and the exploitation.
Any further questions for the trial lawyers this morning? Marcia, thank you. Appreciate you being here. Anyone else want to testify on Senate File 45? Anything else? Any other questions of Senator Nethercott? Is there any public testimony, Pierre? Anyone raising their hand online?
No.
This morning? Okay. I'm going to close public testimony committee. What is your pleasure? Senator Case has moved the bill. Discussion. Any further discussion, committee, on this bill? Okay, Pierre, would you,
Mr. Chairman,
go ahead, Senator
there was
Case.
one suggested amendment. I'm really not inclined to do that, I don't think. So I don't have any changes on the bill. I'd call for the question.
Thank you, Senator Case. I was kind of feeling the same way, and so you saw that I was going to go to the roll call. We'll sure listen, Mr. Laycock, as we go forward with this one. Still going to be room upstairs somewhere, I think, for further conversation there, but please take roll on Senate File 45. Pierre,
Senator
thank you.
Case,
Aye.
Senator Cooper. Aye. Senator Furphy,
Excused?
Senator Schuler.
Aye.
Chairman Landon.
Aye. Thank you, Senator. We'll be right behind you if a fight breaks out upstairs, okay? Yeah, thanks for all your work on that task force, Senator. Good work. We're going to switch up the order just a little bit this morning, everyone. I want to go to Senate File 76, take good care of another fellow senator this morning. Good morning, Senator. Good to see you. See, you're joined by a running mate. That's awesome. Senator Ellis, take it away and tell us about Senate File 76.
Good morning, Mr. Chairman and members of the Senate Judiciary Committee. Before you have Senate File 76.
Excuse me, I think.
A little feedback, and I
That
think
might be
that's
me.
taken care of. This bill came to my attention, or the need for it, from the Human Trafficking Task Force, which is housed within the Wyoming Attorney General's office, and it would amend the prostitution statutes. Currently, we have two sections of prostitution, one for the actual person providing prostitution services, and the other for the person who solicits the act of prostitution. But if you look at the definition, right now, prostitution only covers actual sexual intrusion, as that definition is defined in Title VI. Sorry, holy cow. Yeah, a weekend of cheering for volleyball and not enough coffee. So what this would do, Mr. Chairman, is add an additional definition that's already defined in our sexual assault statutes, and it would cover sexual contact. So if you were to look at that definition in the existing criminal code, sexual contact means touching with the intention of sexual arousal, gratification, or abuse of the victim's intimate parts by the actor, or if of the actor's intimate parts by the victim, or of the clothing covering the immediate area of the victim's or actor's immediate parts. In other words, we've discovered a loophole in our statutes, which, for lack of a better term, we'll just maybe call manual sexual stimulation. And so this particular act in and of itself, we can have the debate on whether or not that should be criminalized, but I can tell you that it is a serious issue in some parts of our state, particularly in Sweetwater County. This act is often a gateway for other more serious acts of prostitution and even human trafficking itself. So we've got the Human Trafficking Task Force here to testify, and I can let them talk a little bit about how this came to their attention, why this is an issue in Wyoming. And I think there are some individuals online. So in the interest of time, Mr. Chairman, let me hand this over to the experts.
Okay, we'll come back to you with any questions, Senator. So committee, have those ready when we come back, but good morning.
Good morning, Chairman.
State your name for the record. You know how that goes. We know who you are, but
My name's Kara Chambers. I am with the Wyoming Attorney General's Office, Director of Division of Victim Services. I'm here today in my capacity as Chair of the Attorney General's Human Trafficking Task Force. I want to let you know that this bill has been a project of the Human Trafficking Task Force for about 5 years. We're very pleased it's made it through introduction. It's the first big step for us. I don't want to take up too much of your time because I do know we have law enforcement online here to testify, as well as our statewide program that works on human trafficking training and awareness with law enforcement and other entities. I guess I just want to highlight some points that might come up. I know that there is some concern about criminalizing the people who are performing the act. I want to let you know that Wyoming has really robust human trafficking statutes, and that includes a safe harbor provision. 62708 is victim defenses and vacating convictions. The reason we would like to see this what we would call it a loophole closed, is that this was brought to the task force attention by the Federal Department of Homeland Security. They were trying to run operations to shut down illicit massage parlors in Sweetwater County and elsewhere, and they couldn't because this particular act was not criminalized in our Wyoming statutes. We believe that was an unintended oversight. And so what some of the municipalities have done is, because there is no statewide law, they've enacted municipal codes to try to address this. The string of criminality that follows human trafficking is vast, and it has an impact on communities. And in fact, communities and countries that have attempted to decriminalize sex work have actually found that there's been a surge in human trafficking and other pimping and other related violent crime, and that comes from the demand abolition and the end demand movement. So there's a lot of research on why criminalizing these acts actually helps victims. We can't go in, law enforcement can't go in and make their case unless they have a state criminal statute. So with that, I will really stand for questions. I really just want to let you know that there's a lot of law enforcement support behind this.
Thank you, Ms. Chambers. Appreciate it. Questions? Excuse me. Same thing, Senator. Any questions for the sponsor of the bill or for Ms. Chambers this morning? Okay, stand by, you two, if you would, please. I'd like to go to other testimony on this bill. Is there anyone in the room with us this morning that wants to testify on Senate File 76? Anyone else? Pierre, do we have someone online?
We have Terry Markham.
Terry? So if you could let them in, and I would ask that you unmute when you get here, and please state your name for the record, but.
Good morning.
Hey, Ms. Markham, welcome. Good morning. Glad to have you here.
Thank you. Good morning, Chairman Landon and committee. I am Terry Markham. I am the Executive Director of Uprising. As Ms. Chambers mentioned, we typically provide a lot of the training around the state regarding human trafficking, and that has included in more recent years a lot of training on a specific type of trafficking that we call illicit massage industry trafficking, which this bill really addresses. As they've mentioned, this has been sort of an ongoing issue for law enforcement. Can you guys hear me okay?
We sure can. In fact, we can hear you too well. So we're just turning the volume down a little bit, but please continue, Ms. Markham.
No problem. I was seeing faces. I really also just wanted to address one of I guess some of the opposition that we are getting on this bill, like Ms. Chambers mentioned, sort of comes from the side of not only would this potentially criminalize the person receiving the act, but also the person providing the act. And as one of the training providers, I just wanted to reassure the committee that there's a lot of care that goes into training law enforcement. They realize that the women who are typically performing this act, they're not just sex workers, they're also victims. As a matter of fact, they're what I would view as some of the most it's actually one of the most heinous types of human trafficking, because these victims are typically experiencing both sex and labor trafficking. In fact, recently in Casper, we had a victim disclose to law enforcement there that she was making 25 yen per massage that she had to provide, which translates to 11 cents in US dollars. So that sort of helps you see like the gravity of this situation and what they're having to do and the debt bondage that they're in, because she'll never be able to work her way out of that debt to be free to go on her own to take part in any type of work that she wants to. I also recently got to actually go to Casper and be with law enforcement during a recent sting operation of a illicit massage parlor. That day, I got to spend pretty much my entire day sitting with the victim that they recovered from the massage parlor, the person who was providing these services. We were really fortunate that she actually spoke pretty good English, and I just wanted to tell you guys a little bit about that experience. But Casper PD did an amazing job with her. First of all, they never arrested her. They did bring her down for questioning, but it was in a very comfortable, safe space. We were sitting on a couch. She was told repeatedly that she was not under arrest, that she did not have to speak to law enforcement if she didn't want to. They were really just trying to keep her safe as they were actually searching and doing work at the premises that they removed her from. She was offered services repeatedly if she needed a safe place to go, if she needed food. Did she need us to help get her transportation? Did she need to contact family? And so that's really what this process is more like for law enforcement. They are not treating these women as criminals. They're not trying to arrest them or anything like that. They are actually taking a lot of care with these victims. Right now in Wyoming, we have, it's really hard to know because they're secretive, but there's as many as 16 to 19 illicit massage businesses in our state, we believe. And so this bill is just really important to us because this could really make Wyoming sort of a leader in this sort of field, this type of anti-trafficking work. Because with 16 to 19, we have the lowest amount of any other state in the country. If we really passed a bill like this that would help law enforcement to have the tools they need to do their job, we could almost effectively eradicate this entire piece of type of trafficking that we have here in Wyoming. And so we just ask for your support on this, and I will stand for questions if you have any.
Thank you, Ms. Markham. I do have a question. Can you tell me once again who you represent? What is Uprising? What is that, a nonprofit? Is it an arm of the Attorney General? Tell me where you work.
Absolutely. Uprising is a nonprofit. And we are all upstream work. So primarily we're doing training of professionals and prevention education around the state. We are members of the state task force under the AG's office, and sort of, I would say, kind of the unofficial training provider of the state, because typically when someone reaches out to Kara's office for training, she oftentimes will refer them to us, as we're pretty much the only boots on the ground training organization that resides here in Wyoming and provides more local-based training.
Okay, thank you very much. Any questions of Ms. Markham? Senator Schuler.
Thank you, Mr. Chairman. My question would be, since we don't, I think this bill will kind of get us where we need to be, but what I'm wondering is, if we don't regulate massage parlors right now in the state, we don't certify them or anything else, and I'm wondering if you think that would help if we got them under the same type of regulations as cosmetologists and others.
Ms. Markham, go ahead.
Chairman and committee, thank you for that question. I would have to say I absolutely agree with you. I think that can be a bit of a heavy lift trying to regulate an industry in Wyoming in particular. But we actually are in the process. We have been working with a lot of legitimate massage therapists across the state, which, by the way, this statute actually really helps protect them as well. For instance, I have a massage therapist here in Sheridan County who's only been in Wyoming 1 year, and she came from a more urban area. And she said she's never been propositioned more than she has since moving to Sheridan, Wyoming for sexual services. So what we're doing as Uprising, and even some of our partners in law enforcement on the task force, is trying to reach out and gather sort of a committee of legitimate massage therapists to start working with them to see, like, where is that line of some regulation that we can have on the industry that helps keep everyone safer and combats illicit massage, but also is it making them jump through a bunch of hoops or taking away their rights? And so I think that's something that we're exploring right now with massage therapists, and just trying to do it in a really thoughtful, cognizant way. But you're absolutely right. This only takes care of part of the problem of potentially working with shutting down maybe some of the illegitimate places. It really doesn't do much to keep new ones from opening. And so I think that's where legislation or stronger city ordinances might be able to come into play.
Okay, further questions of Ms. Markham? Thank you very much for being here, Ms. Markham. Very informative. Appreciate it. Here, do we have anyone else who wants to testify this morning?
You have Michelle Hall.
Okay, if you would please bring her in. Is it Miss Hall? Welcome. Please unmute and introduce yourself.
Good morning, Chairman Landon and committee. My name is Michelle Hall. I work with Sweetwater County Sheriff's Office. Currently, I'm a lieutenant, and I've worked for them for just under 19 years. In the last 5 years or so, I've had extensive training in properly investigating human trafficking. And what I wanted to talk with you about today specifically is illicit massage. Are you guys able to hear?
Very well.
Yes, we can hear you.
Okay. So Terry's right. We have between just under 20 probable illicit massage parlors in the state of Wyoming. The illicit massage industry is actually growing at a rate that compares with the NFL, so around 38%, and that's what's projected growth in the next 4 years. There's actually almost as many illicit massage parlors in the United States as there is McDonald's. So that tells you the scope of the problem. About 5 years ago, when I started getting trained, I attempted to shut down an illicit massage parlor here in Rock Springs in Sweetwater County. My problem, my hurdle with that was what we could prove was going on in that illicit massage parlor was manual stimulation, which did not fall under our state statute. We changed some ordinances in both Green River and Rock Springs, and they added that to the ordinance. But it's still an obstacle for law enforcement, say for a county like me, because I can only enforce state statutes. Basically, that's what happened. It prevented me from being able to do my job and properly investigate that. So I will stand for any questions.
Thank you, Ms. Hall. Chairman Landon had to step out to address a bill of his in another committee, and I'll try to move us forward here as we can. Is there any questions for Ms. Hall from the committee here? And Senator Schuler.
Thank you, Vice Chairman. Appreciate the opportunity. As I mentioned to the last person online, I actually brought a bill, had a bill prepared a couple of years ago because I'd heard problems with some of our massage places in the state. And after I took it around to some of our folks and had them look at it, they felt like maybe it was too restrictive and they didn't really want to see it go forward. So maybe I'll bring that back, but I would certainly look for some advice from our law enforcement and some of the folks in the AG's office, because I think maybe we still need to take a look at that and come up with a way to do that statutorily so that we don't have to rely on the cities to take care of that with ordinances. So appreciate what you're doing over there and just wish you luck.
Thank you.
Thank you, Senator Schuler. Are there any other questions for Ms. Hall at this time? Seeing none, is there anyone else in the room that would like to testify on this bill? With that said, I'll close public testimony. We thank you, Senator Ellis and Director, for your information. And
Thank you, Senator Cooper. Before I leave, I just wanted to ask, I'm looking at a copy of the bill that I got upstairs in our file cabinet, and it doesn't have an effective date on it. I'm hoping that you have one in your copy, and maybe I just have the typo. Oh, it's there. Okay, I just wanted to make sure in case. Thank you.
thank you, Senator Ellis, for bringing that to our, and I don't see one. Yeah, this one does.
You know, I think we're just missing, I don't have that page.
Thank you, Senator Ellis. On my copy, page 3, section 2, this act is effective July 1st, 2024.
It looks like, Mr. Chairman, looks like some people don't have the third page. And the third page, the only thing it has is the effective date. And I don't have the third page, so.
Okay, is that any issue for any of us here?
No.
All right, very good. So with all that said, I'll close public committee. What's your question on the bill? Moved by Senator Schuler. Any discussion? Since you're ready for the question, Bear, would you call roll call, please?
Senator Case,
Aye.
Senator Furphy.
Aye.
Senator Schuler,
Aye.
Chairman Linden,
Excused?
and Vice Chair Cooper.
Aye. Okay, having,
Should we leave it open for Senator Landon to register a vote?
I'm comfortable with that, if all of you are.
It'll pass.
That's fine. Okay, so I guess we're ready to move forward, if that's the case.
Next bill.
Next bill, Senate File 32. Hemp limitations on psychoactive substances, sponsored by the Joint Judiciary Committee. Who do we have here that's going to talk about this today? Good morning, and welcome back to,
Good morning, Kara Chambers, Wyoming Attorney General's Office. I don't believe we are presenting this bill. I just wanted you to be aware that we are here. And I have Sarah Barrett from the DCI Crime Lab in case this gets in the weeds with some questions. But certainly this was a committee bill that you had looked at over the interim and had robust discussion and debate. So I won't belabor that point.
okay? So, is there anyone here who would like to take us through this bill? Senator Schuler, would you be interested in?
Well, certainly, Vice Chairman, just because you asked, I will. However, I voted against this bill, but I do have a question, and part of the reason that I voted against it, and maybe Ms. Barrett can answer the question, is I know you brought forth some questions about being able to test, and that was really the big issue I had. Where are we at with our lab and what we can test and what we can't? That's sort of where I'd like to go first of all, if I could, and then I'll present.
Vice
All right.
Chair, Senator Schuler. Our crime laboratory has the capabilities to test for cannabinoids and to identify them. Currently, we can tell a submitting agency if the THC, and I mean Delta-9 THC, is above 1% in plant material. I believe this bill would add cannabinoids that could be included in that percentage, the way it's written right now. I don't want to speak for Department of Agriculture on their testing capabilities because I'm not sure what those are.
Thank you, ma'am. Is that your question?
Sure.
Okay. Senator Schuler, if you'd
Yeah,
like to kind of lead us through this a little bit?
Certainly. Well, I know this bill was brought forth because of some issues with, I know we had some young people up in the northern part of the state that had some, actually went to the hospital after ingesting some hemp-type products. So our big push, I think, was trying to prohibit the psychoactive substances or synthetic substances that have been somewhere along the line added to hemp. My biggest question when I first read through the bill, right from the very beginning, was, will this bill take away the ability of those people? Because I heard from a number of them in my county, a lot of them use CBD products, and they were concerned about the levels if knowing if they're synthetic, and they wanted to be safe as well. And but a lot of these folks were older people who have issues with arthritis and these kinds of things, and that was partially why I voted against the bill. I do agree we need something in place, and maybe this is where we need to be. The naturally occurring THC, right now with hemp products, it's 0.03% that we can have legally. The psychoactive substances or the sale of hemp with the synthetic substances seems to be the issue that we're having around the state. And so I guess if you take a look at the first page, that's really what the gist of the bill is. On page 2, it just gives us some definitions about the hemp products and talks about with no synthetic substance and with the THC concentration of not more than 0.3% over on page 2. Again, the process, I think that's where we're having some issues, is how it's processed. And I know that there are places popping up all over the state that are selling a variety of these products. And then again, over on page 3, as Ms. Barrett mentioned, and I don't even think I'll try and tetrahydrocannabinol, I can't even say it, so why should I even talk about it? But the Delta-9 talks about the psychoactive analogs, the geometric isomers, synthetic substances, and again, this is the issue that we're having, I think, with substances, and I think this is probably where those young people, again, I don't know exactly what they ingested, and I don't know that we're privy to that information, but I was thinking about trying to bring an amendment, maybe saying something to the effect that, just like we do with our cigarettes and whatnot, that if you're not 21, you can't even go in those shops, period, let alone buy. So that's just something for maybe later today. Over on page 3, just talks about, and again, I did hear from a couple of hemp ranchers, I guess farmers, you'd call them, that raise hemp, and we're concerned a little bit about this bill, but I think we're where we need to be with it on page 4. Just basically says if you're a licensee, you can't produce or process or sell hemp with products that contain more than 0.3% on the dry weight basis. I know we spent quite a bit of time talking about elements of if it was not dry and it was in a variety of different deals, and so I think that's really what we're trying to get at. Over on page 5, talks about the fee if they do find out that they have synthetic substances that are in excess of the 0.3%. Page 6, it talks a little bit about what the fines are. They can get their license revoked. They can be ineligible for licensure for 5 years, particularly if they've had 3 or more violations. Again, and if they are violating this particular chapter, they're ineligible for licensure. Page 7, this is a long bill, again, gets into the naturally occurring. We know that hemp has some THC naturally occurring. So we're just really trying to get at the synthetic and the additives that are added in. So page 8, again, just kind of, I think, solidifies the definitions, hemp product, making sure that there's no plant with more, again, of the THC over 0.3%. And again, it kind of defines, I guess that's already defined in statute, the synthetic substance. So that's pretty much it in a nutshell.
Thank you, Senator Schuler, for that presentation. I think for the lead time I gave you for preparation, I think you did an excellent job. So, Director Schmidt, would you like to add to this at all? Oh, Ms. Chambers, I'm sorry, I've lost it. I'm still on the last.
It's only week 2, sir.
Yeah.
Vice Chairman Cooper, I'm fine. We were just here to stand for questions to make sure there was obviously robust debate and a little bit of confusion, but I think we have it where we need it now, and appreciate Senator Schuler walking through the bill.
Thank you, Ms. Chambers. Is there anybody else in the room who'd like to add to this? You please come forward and state your name and who you're with and give us some insight, please.
Ms. Barrett will actually be in my courtroom in a couple weeks. My name is Loretta Howison-Callis. I am the Uintah County and Prosecuting Attorney. I am here on behalf of the Wyoming County and Prosecuting Attorneys Association to speak on behalf of and in support of this bill and to answer any questions that might provide. Certainly, the association is grateful for all the work you all do, and currently, at this time, I actually have cases for both exploitation and human trafficking pending before my docket, but I am here today related to this bill and to ask for your support. In addition to that, potentially a friendly amendment to 1031. In Evanston and across the state of Wyoming, we have various businesses that are intentionally targeting individuals to facilitate the distribution of what they're calling legal marijuana. Here in Evanston, we have Wild Cannabis. It is a business that advertises and provides for the fact that they are selling legal marijuana, and that is specifically through the Delta-8 derivative. And in this potential legislation, you not only are taking issues related to the synthetic provisions, which certainly we have done before, similarly to spice, but in your 35(7)(1014), you already have a provision that includes the Delta 1 and Delta 6 derivatives of the tetrahydrocannabinol, but you are now proposing including Delta 8. And the reason that that is particularly of concern that we would encourage you to facilitate is those are not necessarily provisional in a CBD. The cannabinoid plant, to my understanding, for the medical provisions that are in the hemp plant, the CBD, that is certainly of issue that Senator Schuler noted. The higher CBD contents naturally in the growing process minimize the psychoactive provisions of the tetrahydrocannabinol. And so these are not individuals that are marketing and selling individuals for CBD products particularly. And certainly I know this entire committee is aware of the hemp bill of 2014 and are aware of the federal regulations for that. But in particular, we are concerned with the fact that in our communities, we are seeing not only for juveniles, but also for adults that are having impacts related to the marketing of those products and for selling, smoking, ingesting, and other provisions. The friendly amendment that Mr. Milekovich, who is the Sublette County attorney, has brought to the committee's attention is in general for the prosecution of any form of tetrahydrocannabinol. Specifically, we could talk about different things, but in our current controlled substances provisions, you have a line for plant form, which is what's tended to see for marijuana. When you think of marijuana, that's what you are considering and thinking of. There's also liquid, and then a crystalline or powder substance is the third subsection that we deal with in those forms. And so the complicated part when you're prosecuting controlled substances, and this includes with heroin. Heroin is often sold in a tar form, which is a waxy black substance. But particularly with tetrahydrocannabinol and what people traditionally might think of marijuana is the way it's marketed at this time. For example, in order to facilitate THC wax, that is actually a highly concentrated form of marijuana. It is chemically not chemically modified. It is boiled essentially and put down into a smaller form so that it's in a wax form. But I would ask all of you to inquire as to where you would put that as a liquid or a plant or a crystal or powder substance, because in fact, THC wax is exactly what you would imagine it. So for it to become a liquid, for example, you would have to boil it or heat it to make it into a situation. However, people are using it, they call it dabbing, and they put it into their pipe and they smoke it, or they otherwise address those issues. And so as prosecutors, we currently, even though that is a highly concentrated form of THC, those are being prosecuted as misdemeanor offenses because they do not fall under any of the subcategories that are provided by statute. A year or so ago, we have a number of stops on I-80 where we have a menagerie of different THC products that are coming in. And for example, we will have individuals that have bread and cookies and gummies and wax and oils. But for example, one of the cases we had was a moon rock. And I actually even had our special agent had to assist me in finding out what a moon rock was. A moon rock is a ball of plant form marijuana that has been then soaked in THC oil and rolled in shatter, which is a powder form. So it falls under all three of those forms. It's extremely potent and doesn't fall necessarily into any of the categories that are provided in 1031C1. And so in relation to issues, the reason Mr. Milekovich is asking for consideration of a friendly amendment is for those issues, and also what you're going to see with all forms of THC, with that Ms. Barrett and the individuals at the crime lab have a hard time when it comes in bread, cookies, gummies, or other issues. What is the carrier agent, and how do we quantify or qualify how we can charge those quantities? I have literally had 50 to 60 pounds of gummies be stopped on the interstate. And those are charged as a misdemeanor because of the fact that we can't provide them as to what percentage in the gummy is actually a liquid or a plant or a powder. And so it is essential when you're understanding the prosecution and enforcement of these statutes that the THC as it's currently provided in statute is very difficult for us to address. And knowing that, in fact, the marijuana that you may smoke is likely much less potent than what you're finding on the streets. But this bill that you have is primarily regulatory through the hemp provisions, and the key component is it does include the Delta-8 derivative into the THC definitions, which just joins other derivatives of the psychoactive elements of tetrahydrocannabinol and binol. I say that in front of a jury quite often, so that it can be provided. So with that, I know you guys are short on time. I would be happy to stand for any questions.
Thank you. That's very informative. Any questions from the committee? Senator Furphy.
Thank you, Mr. Chairman. I'm concerned about on page 4, on line 10, where we have hemp, but it says no licensee shall add, alter, insert, or otherwise include any synthetic substance into hemp. But the penalty seems really small to me, and basically, if they're including, as you're pointing out, some of that nasty substance in there, and it seems like they can only revoke the license if they're finding 3 or more violations in a 5-year period. Maybe I'm not understanding this fully, but it seems a concern to me, Mr. Chairman. And so that's my question.
Thank you, Chairman. Senator Furphy, I understand and agree why that would be a concern. I believe that this bill as drafted is trying to assert 2 separate components. One would be the regulatory factors related to individuals who can sell hemp products, which would be the CBD products and other issues. And there certainly are, both for agricultural purposes, as far as materials. Hemp is an amazing material that can be utilized in a number of different ways, as well as the CBD products. And so I believe that in this statute, the section that you're providing for is to deregulate and to control the hemp producers and the sale of those. For example, if this was passed in its entirety, businesses such as Wild Cannabis, and I'm sure they're very excited that their county attorney isn't calling them out so blatantly at this juncture, but they were on the front page of the news, so we can deal with it. It would provide so that they would lose their licensure for selling the Delta-8 if you then incorporated that in the definition. But as to your concern, Senator Furphy, in the amendments, it includes a modification of the definition of THC, which then also, that's for the regulatory factors, but later down in the same statute, and my apologies, I'm using this online rather than by a page number, but 35.7.10.14, which would be later in your provisions, is defining Schedule 1, which is within the actual Controlled Substances Act. And so, thank you. If you look, then I'm referencing on page 6, lines 15 through 23, and then line 7 specifically on line 12 and 13. By including into the definition there the Delta-8 cis or trans tetrahydrocannabinol and their optical isomers, that will specifically address the concerns that I was providing for, that it facilitates the psychoactive elements that are essentially, because Delta-9 is what's regulated through the hemp provisions, it then facilitates prosecution for individuals who are selling products that include any form of Delta-8, which is the psychoactive elements that are being marketed in some of these stores, not only to juveniles, but to adults, to facilitate a high or to provide for the same substance or effect that the THC would have, that we would normally think of as far as marijuana. Does that answer your question? So this statute is dealing with both deregulating individuals who would add those to their products, as well as facilitating the prosecution of individuals for possessing or selling.
Thank
So
you.
it addresses both aspects.
And thank you for that. Did that help you out there, Senator Murphy? Okay, Senator Schuler.
Thank you, Mr. Vice Chairman. Two questions, actually. Like I said, I've thought about this bill and thought about would it help, particularly with our youth, to be able to maybe add an amendment that they can't even, they can't purchase any of these things unless they're 21. So first of all, let me just ask you if that would help this in some way, shape, or form.
I think that that's absolutely essential, Senator Schuler. I think it is absolutely mind-boggling that our youth can purchase any type of these products when they can't purchase tobacco. And so tobacco would be certainly, it has all kinds of carcinogenic factors, but the medical effects of these drugs on a forming brain is substantial. And so, yes, I think it's essential that that is included. There are some provisions within Title 14 that the legislature addressed last year to minimize some of that, but I don't think it's completely buttoned up.
I have a follow-up there, Vice Chairman. Okay, my second question, thank you, Mr. Vice Chairman, is, okay, going back to page 6, and again, maybe following up on Senator Furphy's question, we're really trying to kind of get at the people that are producing, that they're the processing people that are adding the additives in. How would a business anywhere in the state of Wyoming that is selling some of these products, and they think maybe they are, under the auspices of a legal product because it says it's marketed as 0.03%, how would they know if any of these synthetic substances that change the whole process into something that's not legal, how would they know that?
Well, first and foremost, the naturally occurring plant that they would be growing. Sorry, my apologies, Senator Case.
Go ahead.
Mr. Chair,
I'm sorry.
Senator Schuler, as far as to answer your question, the naturally occurring hemp plant certainly isn't what you would be addressing through this statute, or any of it's a multitude of statutes or any of its provisions. In Uinta County, we have had to facilitate and utilize our crime lab. It was actually before they had some of the testing abilities that they have had, because we have quite literally had truckloads of product stopped in the Uinta County that we have had to address and sent to another lab. It was NMS Labs. To answer your question, without them actually testing their end product, from my experience, they are likely not clear, even if they're within the parameters of the 0.3% for the Delta 9. Because if you allow the plant to grow for an extended period of time, it can, beyond where it's supposed to be, it actually can accelerate different chemical components within the plant, and we could talk about it for a long time. Most of our statutes, and particularly with our statutes for criminal prosecution, you have to have we call it mens rea, a state of mind, and an intention to violate the law. And I don't believe that that is what is the heart of this bill for either the legislators or the prosecutors or the court systems. We aren't here to prosecute or to penalize in any way, for example, a hemp producer who believes in good faith that they are producing plants that are for a benefit, whether it's through CBD or other useful agricultural products that are within hemp. This bill is intended, and the statutory provisions related to the Controlled Substances Act would be for individuals who knowingly and intentionally are selling and marketing, whether it is synthetic provisions that are put into the naturally occurring plant, or ensuring that the chemical process for creating the oils or other issues are enhancing the other components, whether that's Delta 1, Delta 6, or Delta 8. And so that is where I would say the response to, and again, my apologies, Mr. Chairman.
No issues at all. Any other questions for them? Okay, with that, we thank you for your testimony. Is anyone else in the room who'd like to testify? Come forward and state your name and Actually, to keep it a little bit brief, we are going to be up against some time constraints here in a few minutes.
Chairman Cooper, Slade Franklin with Wyoming Department of Agriculture, Technical Services Manager. I'm happy to keep it brief. So
Okay, very
more or
good.
less, I'm just here to answer any questions you have. Our department is responsible for the inspections of the hemp producers and processing facilities in the state. We typically deal with the raw hemp product as it goes to the processing facility. But we do also have record-keeping requirements under our rules and regulations that we have for this program for processing with their products. So with that, I'd more or less just be willing to answer any questions you have with the Department of Ag on our hemp program.
Okay, thank you. Any questions for the Department of Ag? Senator Schuler.
Thank you, Mr. Vice Chairman. Yeah, again, are you guys comfortable with this bill in its present form?
Chairman Cooper, Senator Schuler, we don't see this changing how we run our operation very much. Again, we deal with the raw hemp product, and a lot of this is synthetic, done in the labs. So we don't see a significant impact on the program that we run right now. We certainly have some capabilities for testing of processing facilities under the bill and under the law that we have now, but bear in mind, we have in 2024 right now, we have 4 licensed producers processors and 1 licensed processor only. So amount of processed product in the state of Wyoming is very limited that we are aware of.
Okay, thank you, sir. Senator Schuler, anything more? That answer your questions? Senator Case, anything from you? You good?
No, sir.
Okay, I think that takes care of that. Anyone else in the room would like to testify today? Pierre, do you have somebody online?
We have Richard Jones.
Okay, would you bring Mr. Jones online, please? Mr. Jones, if you could unmute and tell us your name and who you're with, and well, we had him there.
Yes.
There you are.
Good
Go
morning,
ahead.
Chairman Cooper and committee members. My name is Richard Jones. I live in Cody, Wyoming. I'll keep this brief. I have a number of comments very specific to this bill, not the subject in general. I am a member of WYCAN, which is Wyoming Citizens Against Normalization. I have a 40-year background in law enforcement as an EMT, and I had 7 years as a research assistant in neuropsychology, dealing with brain functioning, of course. However, this specific bill in the Joint Committee last fall was, I believe, brought to your attention both in the House and the Senate because of the problems with the isomers of THC, marijuana. The THC as defined was Delta 9 isomer, but there are many other isomers that can be developed from the CBD and hemp. And this was causing a problem in terms of health and safety and complaints from the public and actual people ingesting this substance as it came through the Farm Bill as a loophole in the law that the feds are trying to take care of. Many states have taken care of it. But that was the big discussion last fall in the Judiciary Committee, the Joint Committee. This particular bill, to me, has some problems. I like the definitions on page 223. I think those are very good. And on page 3, 2 through 14. On page 4, it's referenced in line 2 to no person or licensee shall produce, possess, sell hemp products. There's nothing about possession or transportation. On line 16 through 23, it again talks about processing activities by licensees and production. And as the gentleman just stated a minute ago, there are only 4 producers in the state of Wyoming. So this is a targeted bill for 4 producers currently. The next page, on page 5, line 12, again, it talks about licensees. On page 6, number 4, it then refers to if any person, isn't that supposed to be a licensee? Because there are no other references to person. And this talks about the penalty phase. Again, on line 10, it talks about any person who violates this chapter. by producing or processing. Nothing about possessing or transporting. And then on page 10, or page 6, excuse me, on line 10, again, it talks about persons and licensure under this chapter. To me, this bill does not address the problem of selling, possessing, retail marketing, and what Senator Schuler keeps talking about is these gas station stores and others think they're selling a legal marijuana product. There is nothing in this bill that handles that problem. The only thing is it targets our 4 producers. If they violate this 3 times in 5 years, they may have their license suspended. There is nothing else in this bill that solves the problem of the Delta 8 and the other isomers that are of great concern for public health and safety. There's no prohibitions for the sale, distribution, purchasing, age restrictions, or possession of any of these products. It just prohibits Wyoming licensees from producing these products and then wholesale selling them. All these little people selling it, they're not making this stuff. And this just doesn't deal with the problem that was originally intended for. I don't see a lot of harm in this bill, putting our 4 little producers under the gun to not produce these things, which I don't think they're producing these analogs anyway. All this stuff is coming from out of state. There are many other states that have prohibited these things. So I don't see any harm in this bill, but to me, it doesn't solve the problem at all that you all were trying to deal with last fall and the isomers that fall through the cracks of the definition. So in general, I support this bill, but it doesn't solve the problem. That's my comment. It needs some complete redo and work if you want to deal with the Delta 8 isomers that are causing health and safety issues in the state. This bill doesn't do it.
Thank you, Mr. Jones, for those observations. Very well put. Committee, any questions for Mr. Jones? Senator Case?
Thank you very much, Mr. Chairman. I'm thinking that Mr. Jones's questions are kind of beyond, his concerns need to be addressed perhaps by the folks that helped to work on this bill. So I'm perfectly, and some of the concerns perhaps by the prosecutor. I'd like to hear from people we haven't heard before about the issues that Mr. Jones raises, and then also we've got a little bit of time. We've got till 10 o'clock. We don't want to go all the way, but give some folks a little different bite of the apple, because I think folks have been trying to get my attention back there about some concerns that were raised by earlier testimony.
Very good. Any other questions for Mr. Jones? Thank you, Mr. Jones, for your input today, and we do appreciate your thoughts and your observations.
Thank you, sir. Appreciate the time.
So do we want to go back to the room here, or do we have more?
Better get people that haven't testified yet, especially ones that are trying to get your attention right now.
I see that she had snuck all the way to the front of the room, and
Mr. Chairman, I'm trying to be very polite.
maybe you need a rock to throw at me. Go ahead, if you'd introduce yourself and tell us what you have to say today.
Thank you, Mr. Chairman, committee. My name is Kelsey Singleton. I'm a senior assistant attorney general at the Attorney General's office, and I represent DCI, which also includes the crime lab. And I think Mr. Jones's concerns are alleviated with some information from across the hall on House Bill 30. So while this specific bill does not regulate the mere possession, it has to do with the licensees. The language in the bill would affect our Controlled Substances Act, which is 35-7-1031. And so clearing up the distinction between what is legal hemp here in the state and what is illegal tetrahydrocannabinol is still important for the possession, the manufacture, the sale and delivery from a Controlled Substances Act perspective. So I think this bill, in conjunction with some of the other good work that is being done by the judiciary, will rectify some of these concerns.
Thank you. Any questions for the Attorney General's office? Senator Schuler, go ahead.
Thank you, Mr. Vice Chairman. Again, I'll just ask, will it help to add something in on the exceptions about no one under 21 might be able to possess or purchase, maybe not possess, but purchase these items? Will that help this bill at all?
Mr. Chairman, Senator
go ahead.
Schuler, I'm not 100% sure on that. I do know that it is already illegal for them to possess that through the Controlled Substances Act. So I think it would just be additional language that we wouldn't need, but.
Any other questions? Well, with that, we thank you for your testimony, and if you don't bring your own rock next time, I'll furnish one for you, all right?
Thank you, Mr. Chairman.
All right, any other questions from the room? If you would come back forward and readdress what we have going on here, let's, again, would you restate your name, please?
Yes. Again, I'm Loretta Howison Callis. I'm the Uinta County and prosecuting attorney. And I have to respectfully disagree with the Attorney General's office that this bill doesn't address the concerns of Mr. Jones. Mr. Chairman, specifically in relation to page 6, line 15, we start to address the definitions within the Controlled Substances Act that provides for definitions of a Schedule I controlled substance, which is where when I am prosecuting the possession, distribution, sale, or other provisions that fall within the Controlled Substances Act. So that can be possession with intent to distribute or manufacturing or other provisions. It can be possession without the intent to distribute, but when felony or misdemeanor quantities, which is what House Bill 30 is trying to address. Or there are also different, anyways, the definition that is found in subsection Ruminant 21 that starts on page 4 is the sub-reference when we are providing for the prosecution of that we currently have pending for THC. We utilize that definition of tetrahydrocannabinol to prosecute anything that is not in plant form. And so in that provision, this statute or amendment proposes to include specifically on lines 12 and 13 the delta 8 cis and trans tetrahydrocannabinol and their optimal isomers. So at least in the production or sale of the items that is in my community, that would facilitate me prosecuting the sale of those items, which is specifically what Mr. Jones was asking about. Thank you.
Okay, one quick question for you. Would you say this addresses the concerns you have as is, or do you feel it needs amended quite a bit to do what we need to do?
I think this bill is Mr. Chairman, I think this bill is a substantial step towards at least being able to address some of those issues. But as noted, whether it is in this bill through a friendly amendment, which I don't know where it would be located, or through a friendly amendment to House Bill 30, there does need to be some time that we are addressing the form question for tetrahydrocannabinol, because neither of these bills in their current drafting facilitates us to prosecute effectively gummies or wax or other individuals that don't fall within those traditional itemizations that fall within our controlled substances, which are the powder, crystalline, liquid, or plant forms. But it is a substantial step in the right direction.
Okay, thank you. Any other questions from the committee here? Anybody else on the floor that'd like to address this simple little bill? I see one here.
So, Mr. Chairman, Senators, I'm here.
It's got to be on.
Come on up, please, sir, so we can get you on the mic.
And I'm under certain.
If you could come in and sit down.
You got to put it on the microphone, though. Sorry.
So we can get you publicly here. If you could state your name and your affiliation, and then tell us your concerns there.
Mr. Chairman, Senators, my name is James Lake. I'm an intern with the University of Wyoming, here enjoying this session. And I've actually I'm under obligation not to be partisan. So if addressing this committee violates that, I'd like to know now, and I will retract. And because I really enjoyed my
Mr. Chairman.
Mr. Case, Senator Case.
I think the gentleman can certainly speak as a private citizen and entitled to any of your opinions, even though they may be partisan. As an intern or kind of an employee of the LSO, You could not. They're two different things.
Thank you, Senator Case. Sir, if you want to go ahead and
Thank you, Senators.
Tell us your
I
concerns,
want to
sir.
speak in support of this bill. You know, the products that the Wyoming hemp people are putting out and the products that the other states are putting out that are marijuana are almost indistinguishable when you look at them. It's really sad in my mind, with as useful as the hemp plant is, that the people of Wyoming that legalized it are actually doing this kind of stuff with it, producing synthetic chemicals, you know, and passing them out to people, when yet the real stuff that's far more safer is illegal. So I just want to say that, and I think the 21 age limit on any of this stuff would be a great idea. And you know, the hemp plant has many different varieties. The varieties they grow for CBD is far closer to the marijuana plant than it is industrial hemp. I'm currently doing research on the hemp plant. I really hope to maybe even spur a biofuels industry here in Wyoming using hemp. But I just want to say that I think you should illegally, all hemp-derived CBD products, Delta 8 on that, should simply be illegal. That's all I have to say, Mr. Chairman, Senators. Thank you.
Thank you, sir. Any questions for the gentleman? No questions? Senator Landon, Chairman Landon, welcome back. I think I got us through a little bit of this hemp bill, but
You just keep going, Mr. Vice Chairman. You got it. I'm right behind you if a fight breaks out.
I've already got the Attorney General throwing rocks at me, and Ms. Chambers, I misidentified her, and I apologize for that. And any other, come forward and identify yourself. And we are a little bit short on time. We got to work the bill yet, and I'd sure like to get this finished up.
My name is Rhea Parsons. I am with the Wyoming Prevention Action Alliance, which is a statewide substance abuse prevention coalition under the umbrella of the Wyoming Association of Sheriffs and Chiefs of Police. I just wanted to address really quickly, just to give you a broad stroke, our coalition is made up of statewide partners as well as community coalitions that work towards the prevention of substance use. And I wanted to answer, Senator Schuler, your question about making it illegal for those under 21. First of all, we support everything that's going to tighten up this loophole around the Delta variants under the hemp derivatives, because of course that is, of course, a problem across the state, not just in northern Wyoming, but everywhere. Always, if we even look back at tobacco and alcohol, whenever we raise the age limit for both purchase and possession, we reduce youth, it helps to reduce youth use rates. So I just wanted to chime in on that of course, it does seem counterintuitive that 18, 19, and 20-year-olds can purchase this, especially since some of them are potentially still in high school and can redistribute those products to kids in school. Keeping it out of the hands of youth is something that is an ongoing situation for us, but whatever we can do to tighten up those policies and help youth get beyond the age of 21 without putting substances in their body is something we're all shooting for. So, thank you. Any questions?
Thank you, Ms. Parsons. Any questions from Ms. Parsons? Seeing none, we'll move forward. Any other comments from the floor, in the room? And Pierre, there's no one else online? Okay, with that said, I guess we'll close public comment, and I'm going to turn this back over to him at this point.
Okay, Mr. Vice Chairman, you were doing great and could have kept going. With public comment closed, committee, what's your pleasure on this bill? Senate File 32. Okay, moved by Senator Furphy. Discussion. Any discussion? Appreciate you carrying forward, committee, and sorry I had to be gone. I was next door battling labor and health issues. And this is a little bit of labor and health. Senator Schuler, did you have a?
Yes, I do. Thank you, Mr. Chairman. First off, don't leave again, because the Vice Chairman put me on the hot seat, and I'm not sure I was ready for that, but
absolutely.
Anyway, I'll go ahead and offer the amendment. I think it belongs in, and I appreciate the testimony from the AG's office, that maybe we don't need it, maybe it's taken care of, but just maybe to just add a little more power to this if we're moving this bill forward. And I think it would probably go in 1151-103, where it talks about prohibitive activities. But I don't know if it would be on page 4, line 13. I don't know if it would be a G or if it would be 3 little I, but I will just add the amendment. No one under 21 will be able to purchase hemp with THC or psychoactive substances.
Okay, does everyone understand the proposed amendment?
May you repeat this slower,
You
please?
bet. And again, I may need some help if this is the right place for it, but page 4, line 13, and I don't know if it needs to be G or if it needs to be 3 little I, but no one under 21 will be able to purchase hemp with THC or psychoactive substances.
Okay, committee, discussion? Any discussion on the proposed amendment? Senator Case?
Well, Mr. Chairman, did I understand the testimony that we received to be that this is already covered?
Senator Schuler, can you speak to that? I'm sorry I wasn't here.
Yeah, Mr. Chairman, I think they mentioned somewhere else in statute, and I don't know, maybe Ms. Singleton can talk about it again, but that it may already be covered. I didn't know if it would be helpful or just, I don't want to
Yeah, thanks, Ms.
I don't want to
Singleton.
muddy the waters.
Thank you
either.
for coming forward, and I apologize for being
And
gone.
may I
It'll-
tag on that question?
It'll help me too, and yeah, absolutely, Senator Case.
So sometimes we think we're doing the right thing by putting repeated references to the state of the law in different places. And sometimes that causes confusion too. So maybe Ms. Singleton could
That's good
address that.
caution. So speak to us about this proposed amendment, Ms. Singleton, would you please?
Thank you, Mr. Chairman and committee. It is currently in 35.7.1031 because those substances are illegal for everyone.
Can you
So
cite that again? 35,
35.7.1031.
1031. Thank you.
Mhm.
And please continue.
And so under 1031, that's the illegal possession, manufacture, delivery of controlled substances. And so it would be illegal for those under 21 because it's illegal for all in the state of Wyoming. I do appreciate the emphasis because I think, maybe for those that are unaware that the statute is there, it does clear things up. I think probably my only hesitation would be from a statutory interpretation perspective is if we're saying those under 21 can't have it in this section, then does it imply that you can have it if you're over the age of 21? And so I think just from an interpretation perspective, that's probably my only concern. Otherwise, I certainly support that we need to make it clear.
Thank you for that. Senator Schuler.
And again, Ms. Singleton, thank you, Mr. Chairman. I'm wondering just where we just have purchase here rather than possession. Does that make a difference where the statute in 35.7.1031 talks about probably possession? I don't know.
Mr.
Go ahead.
Chairman, Senator Schuler, I think that is a good point, although I think purchasing would fall within the possession. There's also intent to deliver in there. So I think I'm not sure the intent of this committee, but the intent might be that we're trying to stop it from being sold here and not really going after the young folks that are trying out the substance. And so I think the intent to deliver component of 35.7.1031 tries to cover that.
Thank you.
Okay. Committee, any further questions? Really appreciate it. Thank you.
Yes.
So we're back on an amendment. Any further thoughts, Senator Schuler, based on the feedback we just got?
Thank you, Mr. Chairman. Now I'm not sure yet. I don't want to, I want to give a little impact. And I was hoping maybe with the purchase rather than the possession that would take care of it, but I'm happy to withdraw that also. If it's going to muddy the waters, there's no sense in doing that, so I'll withdraw it.
So Senator Schuler has withdrawn that proposed amendment. Is there anything else, committee, on this bill? We've worked it throughout the interim. I'm inclined to go to a vote. Okay, Pierre, would you please take roll on Senate File 32?
Senator Case,
No.
Senator Cooper,
Aye.
Senator Furphy,
Aye.
Senator Schuler,
No.
Chairman Linden.
Aye.
3 ayes, 2 noes.
So, committee, that wraps up the work for this morning. I do want to talk about if Senator Cooper, would you consider carrying this up on the floor?
I'll take a stab at it.
Take a stab at
I have to,
Consider, yes.
I have to be absolutely honest with everybody in the room. I think the last thing I smoked was a Marlboro back in 1976. And that's because I dated the Marlboro man's daughter. But I just don't know this part of the world as well as I wish I did. I think this is important work, and we're going to go forward and try to represent it. And as we have said on this committee before, we'll find out, what concerns people might have along the way. But appreciate all of you. Sorry I missed some of the testimony, but thanks for all the input this morning from everyone. Regarding tomorrow, we have a couple of special meeting times. Just to remind, we're going to try to meet at noon, and we will meet again upon adjournment. We have, believe it or not, some property tax bills that we've got to get to. There may be a couple of other bills sprinkled in. Wednesday morning, we will meet at our normal time and take up the vape cartridge bill that you may have heard about. That bill will be up, and then a minor name change bill. So we'll get those, but committee will be working tomorrow primarily to try to get some property tax bills back up to the Senate. And so be ready for a busy week. Okay, we're adjourned.
I would like to say that Senator Schuler did